Ready? Welcome to the regularly scheduled meeting of the Community Development and Regulatory Services Committee for today, November 18th. I've been joined by council members Cano, Quincy, Fry, Reich, and Morsami, which is everyone on the committee. Thank you all for being here today. We have a consent agenda that includes a large number of items, starting with item number 14 and moving through item number 28. Are there any items anyone would like to pull off the agenda, items 14 through 28? Seeing none, I'll move the consent agenda. All in favor signify by saying aye.
Aye.
Any opposed? Those items are approved. We also have a lengthy public hearing agenda. We'll start with the first three items, all pertaining to Broadway Flats, and I'd invite Ms. Glasper up, and perhaps, are you giving the reports on all three?
Yes, I am.
Perhaps you can just run through all three reports, and we'll ask the clerk to open the public hearing on all three items.
Sure, happy to do that.
Thank you.
Thank you, Madam Chair. The first item before you, excuse me, is a staff recommendation to approve up to $13.9 million in tax-exempt multifamily housing revenue entitlement bonds for the Broadway Flats Affordable Housing Project. The project will be located at the northwest corner of the Penn and Broadway intersection in North Minneapolis. The project is in the Jordan neighborhood, Ward 5, at a location that was identified as the epicenter of the May 2011 tornado that hit this area of the city. The project site consists of 8 parcels of land and a small portion of a 9th parcel. 6 of the parcels are city-owned and are the subject of a land sale that will be heard in just a few minutes. The project is new construction 4-story building containing 103 units of affordable rental housing in a mix of 0, 1, and 2-bedroom units. Rents will be affordable at or below 50 and 60% MMI. In addition to the housing component, the project will also contain approximately 18,000 square feet of commercial retail space, 63 underground parking spaces for the residents, and 29 shared surface parking spaces to be shared with an adjacent church. An integrated transit stop is also included, along with public bicycle parking and lockers, public art, and a variety of other public pedestrian amenities. The commercial retail space will be anchored by the Broadway Liquor Outlet, which is a long-standing business in the community who will both own and operate the space. There will also be a small laundromat, and there remains space for up to, I believe, 3 additional commercial retail tenants, although I know that the developer is pushing for just a single additional tenant. The project is intended to eliminate blight, create and enhance the pedestrian experience, and generally activate this very important corner in North Minneapolis. The total development costs for the project are approximately $23.4 million, of which about $15.5 are through private sources. Private financing represents about 66% of the total development cost, and public funding makes up the remaining 34%. Development equity into the project is at about $427,455. The bonds carry an automatic allocation of 4% low-income housing tax credits, which will generate about $8.4 million in syndication proceeds. The syndication proceeds are also considered equity to the project. The bond issue will be bifurcated into a Series A bond in an amount of approximately $11 million and will be secured by a first mortgage on the property and credit enhanced by a HUD loan guarantee. The Series B bonds will be in an amount of approximately $1.4 million and will be secured by the TIF note and also credit enhanced by the HUD mortgage. The developer fee is just over $1.6 million and is well within our underwriting guidelines and the housing developer fee policy guidelines. Regarding the land sale, we're recommending the sale of 6 city-owned parcels and the signing of a joint application for a certificate of possessory title and registered land survey. The 6 city-owned properties are located at 2413, 2423, 2425, 2503, 2507, and 2511 Penn Avenue North. There are also properties that are held by the developer located at 2419 Penn Avenue North, 2220 West Broadway Avenue, and the developer also has a purchase agreement for a very small portion of the property at 2512 Queen Avenue North. We are recommending the sale of the city-owned properties for an amount of $152,256, which is equal to about $4 per square foot. The city acquired these properties at various times under the Vacant Housing Recycling Program via tax forfeiture and also through the Neighborhood Stabilization Program. Properties acquired under the NSP program will have the land sale proceeds for that parcel returned to the program to cover ongoing costs. The developer submitted an acceptable offer to purchase for the 6 city-owned properties as part of their overall funding application for the project. The Jordan Area Community Council and the Broadway Business and Area Coalition have both had an opportunity to be briefed on the project, and they have submitted letters of support. The filing of a joint certificate of possessory title and a registered land survey is being requested by the developer in order to facilitate the construction timelines for the project, and these actions do not represent any additional cost to the city. Regarding the tax increment financing, the developer's tax increment financing application, and pardon me, I'm going to stop. If you will permit me, I am foregoing a detailed description of the project in the 2 subsequent reports. Thank you. The developer's tax increment financing application requested $1.5 million in pay-as-you-go TIF assistance. Staff analysis has determined that the project site qualifies as a housing TIF district, and further that the project would not be feasible but for the availability of this funding source due to the extraordinary costs associated with developing at this location. This area of the city has been disproportionately affected by the foreclosure crisis and was also subject to a national disaster in May of 2011. The project will eliminate blight, provide jobs and affordable housing units, and will enhance the public pedestrian experience at the intersection. Staff have determined that the tax increment financing assistance is justified in an amount up to $1.4 million, to be exact, $1,424,300. The assistance will be provided to the project through the issuance of a pay-as-you-go revenue note, carrying an annual interest rate of 4.95%. The note is projected to be paid off with 26 years of tax increment collections. The note will be used to reimburse the developer for qualifying construction and site costs and will be assigned to the first mortgage lender, Great Southern Bank. Staff are continuing to work with the developer and his team to determine the specific recapture provisions that will be included in the redevelopment contract.
Okay, I actually have a question, and I'm not sure if anyone else has a question. And this is maybe a question for Mr. Winkelhaeg or Ms. Crowther or yourself. I just in the interest of learning something and trying to get a sense of how these projects are put together, can you explain, with the housing revenue bonds, they're secured by a mortgage, so that means the rent essentially pays them back, correct?
That's my understanding, yes.
Pay a mortgage on the bonds, just like anyone would.
But the second portion of the bonds are noted in your report is to be paid back by the TIF note. So is it the revenue from the tax increment that goes to pay off the bonds and that's the use of the tax increment? Or there's a separate TIF note for that portion? How does that work?
Mark, do you mind? I may have misstated.
Well, I'm Mr. Winkelhaeg, I'm looking at financing information. The Series B bonds in the amount of approximately $1.5 million will be secured by a TIF note and credit enhanced by a HUD 221/40 loan guarantee. Right. Is that different than the TIF that we're talking about, giving the development for associated costs? Is that the same tax increment, and is it the use of the TIF that pays back the bonds?
Yeah, Madam Chair, council members, the city would issue a TIF note that would be assigned to the bondholders, basically. So the TIF does go to pay bonds.
So it doesn't go into the project costs to pay for land acquisition or parking or something like that. It's one TIF note, it's up to $1.5 million, and essentially it's part of securing the debt financing as equity?
Well, the bond proceeds will be used for those various purposes, some of which are TIF eligible. So you'll have to sort of assign certain costs, bond costs, that will be paid back with tax increment.
But it's one tax increment contribution, and it's essentially going to secure the housing revenue bonds.
Correct.
And pay back the housing.
Pay back a portion of the housing revenue bonds.
And then if that wasn't enough, that's where the loan guarantee comes in.
Yes, correct.
Okay, great, thank you. Are there any other questions on items 1, 2, or 3? There's a lot of actions in front of us. They include the housing revenue bond financing, the tax increment proposal, as well as the land sale. Seeing no questions from the committee, we'll open the public hearing at the clerk's direction on items number 1, 2, or 3. Is that acceptable? Okay, is anyone here to speak to this issue? Really? No one? Come on, Mr. Min. I will note that there's been a lot of talk lately about the fact that projects in the north side are all being done by nonprofits. Are you a nonprofit?
Madam Chair, members of the committee, decidedly not. Steve Min with Loopy Development and my partner Dean Rose with Rose Development, we are pleased to be for-profit affordable housing developers. And that entity, that kind of existence does actually exist in town. There are several other for-profit developers who do affordable housing good work. This project would not have been possible if not for our superior team effort led by Tiffany Glasper at CPAD. She's done a phenomenal job helping us pull this all together. I will simply say that it is a complicated finance structure. It's not typical to assemble this many pieces of land with this many pieces of subordinate financing, but that just sort of underscores the uniqueness of the project and the uniqueness of the need. Not only are we overcoming high costs and a neighborhood that has a gap in terms of market rate rents, but we're also trying to establish a foothold in the middle class in this neighborhood, and that requires a little bit of extra in terms of what we build. So indeed, we have a phenomenally exciting project. We've had great support from your team. We do have, I think, a team that's ready to break ground at the end of February, which is pretty exciting. And were it not for the city support, I don't think we would have gotten our funding partners, the state, Met Council, DEED, the County Affordable Incentive Fund, and the Transit Oriented Development Fund. We're touching all sources. And if it were not for the city's early commitment with Affordable Trust Fund and TIF, we wouldn't have gotten there. So I thank you for that, and I'm happy to take any questions you might have about how we pulled the project together.
Are there questions for Mr. Min or anyone on his project team? People who are here on this project, raise your hand.
Oh, come on, put them all up wheel high. Come on. Got a big team here.
This would be extraordinarily quick timeline to pull a project like this together as well, because it wasn't really contemplated prior to the tornado, correct?
Madam Chair, that is correct, and we also had an interesting stop in the middle. We were originally a smaller project, 74 units and much less retail, and the planning staff and CPAD actually came back to us and said, what would be left on Penn would be an unsatisfactory infill. Would you consider stopping, going back, redesigning, and making a bigger project, bigger impact? And if it were not for my partner's willingness to do that at considerable cost and risk to him, and the city made it worthwhile to us by giving us some of these additional parcels at a fair price, we would not have been able to do the project that you're looking at today.
Great. Thank you for your testimony. Is there anyone else here to speak to this issue? Anyone? Anyone? Seeing none, I'll close the public hearing. Councilmember Quincy.
Thank you, Madam Chair. I'd be delighted. First of all, thank you for everybody. If I could comment briefly on all this, it's as Mr. Min just described, a work by many that came to a much bigger, a better project with having more significant impact on behalf of the residents of North Minneapolis. So thank you for all of that. I guess I'd like to move approval of all 3 items brought forth by staff recommendation on items 1, 2, and 3.
On the motion to approve items number 1, 2, and 3, all in favor signify by saying aye.
Aye.
Any opposed? That item is approved. Mr. Min, I'd urge you to stay for item number 4. You might be interested in the outcome of something you worked on when you were here. Yeah. 50th in France, yeah. We're going to talk about that next. We're still trying to fix that. We'll move on to item number 4 then. Mr. Winkelhake, welcome.
Thank you, Madam Chair. Madam Chair, council members, what you have before you is modification number 1 to the 50th in France TIF plan. This is an administrative modification. It does not involve extending the TIF district or providing any additional assistance to the note holder or developer. The district was established back in 1998 as a renewal and renovation district. It has a life of 16 years, 15 years plus, 15 years from the first increment collection. The first year was 2002, and the last year will be 2017. At the time the district was established, a pay-as-you-go note was issued to the developer for $1.8 million with an interest rate of 7 3/4. And a budget was put into the TIF plan that totaled $2,725,000. There was an error in that budget. That budget should have been approximately $4 million. So the state auditor has noted the error. We've noted it, and this particular amendment simply corrects the budget to be more in line with what has actually happened over the years. What has happened over the years is there was property tax reform in 2001, and so the district has never generated as much increment as was originally projected. It's still going to go out the same term. It'll be done in 2017. The note holder will not get as much money, but at the end of the term, you know, one of the advantages of doing pay-as-you-go financing is if it doesn't pay off, it's forgiven. So at the end of 2017, whatever is left outstanding will just be forgiven, and the district will be decertified and put back on the tax rolls. So happy to answer any questions.
Are there any questions for Mr. Winkelhaeg? There is a lot of confusion about this. Councilmember Fry.
Sure.
I guess I don't even really know where to start on the questions. But so you said, so it is a pay-as-you-go TIF district.
Yes.
My understanding of a pay-as-you-go TIF district is that the individual pays the remainder off if it's not met, or the business, the entity. Is that not accurate?
Madam Chair, Councilmember, no, that's not.
Okay.
It's a note that we issue to the developer, and it has an interest rate, and as the TIF district goes out over time, the increment is used to pay the principal and interest, sort of like paying, you know, your mortgage down. If the increment is greater than projected, it may pay off early. If it's lower than projected, which is the 50th in France, at the end of the term, whatever's left outstanding, let's say
Pay back to the developer.
is not
Not going to be
is
paid to
not
the
paid
developer.
off.
So we
It's
don't
just, it's sort of like if there was $500,000 left on this note at the end of 2017, it just disappears. It's gone.
And the developer eats the cost of
And the
that.
developer is never fully paid back for the $1.8 million.
Okay,
did have it right.
that was my question.
yeah.
That's right, okay.
Right. And that's the risk that developers take, and that's why we do pay-as-you-go financing, because the risk is all on the developer's side.
And I'll note that Councilmember Min was the one pushing for the pay-as-you-go note. At that time, they weren't even doing pay-as-you-go notes. The city was just covering the cost, and this was one of the very first pay-as-you-go notes that we did, and good thing we did.
Right, back in that time period, the city often did bonding, in which case the city is taking the risk that there will or won't be enough tax increment available. Since that time, we've almost exclusively done pay-as-you-go, with a few exceptions.
So can you tie that to the TIF issue we just dealt with? If the on Broadway Flats, should the TIF not be enough, there's a loan guarantee in place.
Yeah, if the TIF's not enough, there are other, other financing vehicle or other financing security that will have to pay back the bonds because they just, there's not enough tax increment. Now, we hope that our projections are conservative and that actually there will be perhaps more tax increment, and then a portion of the bonds will be paid off early.
And we have that on our agenda today, too. There are decertifications on our agenda
Right.
today.
Yes, there's a number of those that are on consent.
Are there other questions for Mr. Winkelhaeg? Thank you. I think that was a pretty good explanation. This is a public hearing on item number 4, which is an administrative modification to item number 1 of the 50th in France Tax Increment Finance Plan. Is there anyone here to speak to this issue? Anyone? Anyone? Seeing none, I'll close the public hearing. Councilmember Fry.
Thank you, Madam Chair. I move approval of this item.
Approval of item number 4 has been moved. Further comments or questions? Seeing none, all in favor signify by saying aye. Aye. Any opposed? That item is approved. On to item number 5, Hiawatha Academies. Ms. Shaw, welcome.
Thank you. Good afternoon, Madam Chair, members of the committee. We are requesting to pull the authorization for host approval on Hiawatha Academies from the agenda. We are originally going to issue these bonds through the city of Cottage Grove, and it is my understanding that we're now going to issue them through the city of Minneapolis in 2015. So we're asking to pull that item from the agenda. We do have individuals from the project here to answer questions that you might have for them going into next year.
Okay, so this is a public hearing, so we need to open it as a public hearing because of the way we've been noticed. But as Ms. Shaw said, we're going to bring this forward at the beginning of next year so that we'll have money in our entitlement to be able to do so. So thank you for your report. We'll open the public hearing on item number 5, which is the Hiawatha Academy Middle School. And this would be moving to delete this from the agenda with the understanding it will be brought forward at the beginning of next year for approval when our entitlement is large enough to be able to do that. Is there anyone here to speak to this issue? Anyone? Please step forward, state your name and address for the record.
Good afternoon. My name is Sean Elder. I'm the Chief Operating Officer at Hiawatha Academies.
Wow.
And just wanted to recognize the committee and let you know that we're very excited to be able to have the bonds be issued through Minneapolis in January. We're a Minneapolis nonprofit and open enrollment charter school, and we serve Minneapolis students, and we're excited to have this in January. And so we have a community meeting tomorrow night, actually, and I'm very interested in participation in that, and have been engaged with the community for a number of months as well on this. So very excited to come back in January.
Great, thank you for your patience. Is there anyone else here to speak to this issue? Anyone? Seeing none, I'll close the public hearing. Councilmember Quincy.
Thank you, Madam Chair. I would like to move to, do we actually move to delete, or is it a move to vote no on this particular offering? Move to delete this item. Because as Mr. Elder just mentioned, of course, there is a community meeting tomorrow, and it's really important to the Northrop community to understand what's happening in the building and all of those kind of impacts into the neighborhood. The neighborhood has been supportive of the project with some expressed concerns. This gives us the opportunity from a neighborhood basis to do this. Appreciate Hiawatha's interest in doing business with the city next year, as we have that capacity in our bond issuance. So I'd like to move to delete this item from the agenda.
Further comments or questions? Seeing none on Councilmember Quincy's motion to delete from the agenda, all in favor signify by saying aye.
Aye.
Any opposed? That item has been deleted from the agenda, but we will expect it back then in January. We'll then move on to item number 6, Pizza Luce. Mr. Wilson.
Thank you, Madam Chair. Pizza Luce 4, Inc., doing business at 2200 East Franklin, is requesting an expansion of premises to add 3,000 square feet to their seating area. This is into a very nice building that meets all of our requirements. We did a public hearing notice to all residents and property owners within 600 feet. And we notified the neighborhood and the business associations. We've received no responses to date. This application meets all of our requirements, and staff recommends approval.
Are there any questions for Mr. Wilson on the expansion of premise? Seeing none, we'll open the public hearing on item number 6, which is an application for an expansion of premise for Pizza Luce. Is there anyone here to speak to this issue? Anyone? Please step forward, state your name and address for the record.
My name is JJ Haywood, and I'm the CEO of Pizza Luce. So we're super excited to have this expansion of Pizza Luce Seward, which has been in the community for nearly 11 years. So we'll be doubling our restaurant space and fully renovating our dining room, as well as adding kitchen space, which will allow us to do Saturday and Sunday brunch.
Oh, cool. That's great. Thank you for being here today. Is there anyone else here to speak to this issue? Anyone? Seeing none, we'll close the public hearing, and I'll move approval of the application for an expansion of premise. All in favor signify by saying aye.
Aye.
Any opposed? That item is approved. We'll move on to item number 7, Volstead's Emporium. Mr. Wilson.
Madam Chair, committee members, we have a new application for a new restaurant with an on-sale liquor license Class C from the Volstead's Emporium to be located at 711 West Lake. This will be a full-service restaurant with live entertainment. They will have interior seats with a capacity of up to 123 persons, and they will have no exterior seating at this time. It's a 2-member partnership. John Braun and David West are co-owners of this business. We mailed out 445 notices of this public hearing today. It was to all property owners and residents within 600 feet. We also notified the Lake Street Council, Carrick Neighborhood, and the Lynn Lake Business Association. We received no responses from that mailing. The applicant meets all of the requirements of ordinance, and staff's recommendation is to approve.
Are there any questions for Mr. Wilson on item number 7, which is a new business at 711 West Lake Street? Seeing none, we'll open the public hearing on item number 7. Is there anyone here to speak to this issue? Please step forward, state your name and address for the record.
Good afternoon, Madam Chair and esteemed members of the council. My name is John Brown. I am one of the members of the LLC that's proposing this project. The other one is seated right here. It's David West. What we've come up with is a neighborhood restaurant and bar that is in the style of a 1929 speakeasy. It is in fact located in the basement after the 18th Amendment was passed in 1919. All drinking establishments went underground and wound up in the basement. So this is replete with the secret entrance door off of the alley and all of the accoutrement that accompany a speakeasy. And we've been trying to kind of keep the word low in order that it will have a little bit of its secret flair. But to the extent that we've had an opportunity to speak to people, including Council Member Bender, there seems to be quite a bit of support in the neighborhood for such an establishment.
Thank you for your testimony and for being here today.
Thanks for having us.
Not often do both of the owners come speak to their liquor license. I think it really rings well with the committee. Thank you for being here today.
Thank you.
Is there anyone else here to speak to this issue? Anyone? Anyone? Seeing none, I'll close the public hearing. Councilmember Quincy.
Thank you, Madam Chair. I'd like to move approval of this item.
Approval of item number 7 has been moved. All in favor signify by saying aye.
Aye.
Any opposed? That item is approved. We'll move on to number 8, temporary extended hours of operation license ordinance change. Mr. Wilson.
Thank you, Madam Chair. Today, the committee is to consider an ordinance amendment proposal that will allow commercial and business activity to occur outside of the normal hours of operation allowed for such things as special events and business promotions. The temporary extended hours will be managed by the issuance of a temporary license. Members from the business community have requested the opportunity to increase their role by keeping their businesses open later than their authorized hours during these events and promotions. We have regulated in specific of hours of operation based upon the zoning category that the business is located in. Generally, permitted hours of operation near residential properties are more restrictive than businesses located downtown or in entertainment and activity nodes. Staff has prepared reasonable parameters for issuing and regulating temporary hours of operation. They will have, the way the ordinance is prepared now, that businesses will have up to 35 days per year where they can apply for temporary extended hours licenses. The application process, I believe, is simple and requires a fee of $70 per application. Businesses with liquor licenses or any alcohol licenses are not included in this amendment. This is for non-alcohol businesses. This amendment does support the city goal of a hub of economic activity and innovation. Businesses big and small start, move, stay, and grow here. We did notice this public hearing, an amendment proposal. We sent notices to all neighborhood organizations, all business associations, all licensed businesses, and we put this on our website approximately 10 days ago. We received 3 responses. All responses are in support of this amendment. One is from the Lake Street Council, and the other 2 in support are from current businesses. That concludes my report. If you have any questions, I'd be happy to answer them.
Questions? Councilmember Frye.
Thank you, Madam Chair. Mr. Wilson, how would this impact downtown bars and restaurants that want to be able to sell food after 2 a.m.? If at all.
Madam Chair, Councilmember Frye, currently ordinances allow on-sale alcohol establishments downtown to apply for an all-night special food license. Historically, there was also eligible an all-night entertainment license. That provision was repealed by the City Council about 10 years ago. So currently, this will not have any effect on anybody who has an alcohol license and will be of no benefit to them. It will be just non-alcoholic businesses that will benefit from this. I have had several inquiries, and one of the inquiries in the public hearing notice is why not extend this to businesses that have alcohol, even though the alcohol would stop at 2 a.m.
Well,
They
doesn't the
could
state
still-
doesn't the state prohibit us from keeping bars open later than 2 a.m.?
Madam Chair, the state law and our liquor laws have to be the same in that no one can serve alcohol in the state after 2 a.m. People have to finish consuming that by 2:30. We do believe that we could allow people to stay open for other activities like we do now for all-night special food licenses and how we did it previously with all-night entertainment licenses. So I certainly think we could modify this amendment through another chapter to allow alcohol places to stay open if that was the council's wishes.
So, Mr. Wilson, could you explain kind of the general parameter or categories of people who would be affected by this?
Madam Chair, I believe that we have several hundred restaurants, other retail shopping venues, some of our special events, things like that. So several hundred businesses could stay open later on special events for business promotions, even businesses that we don't license. So for example, a hardware store that we don't license still has to comply with the hours of operation listed in our code based on where they are located in a zoning district. So anything pretty much out of downtown or a very heavy commercial node is they have to be closed at 10 p.m. during the week and 11 p.m. on the weekends. So businesses like that can apply right now, and gas stations can apply for a full year extended hours license, and this committee reviews those applications from time to time, and we hold a public hearing. So many businesses could benefit from this.
Okay, thank you. Are there any other questions for Mr. Wilson? Okay, seeing none, we'll open the public hearing on item number 8, which is the temporary extended hours of operation license ordinance. Is there anyone here to speak to this issue? Please step forward, state your name and address for the record.
Good afternoon, everyone. My name is Hussein Ahmed. I have a business at 415 Cedar Avenue in Cedar Riverside area, and it's suite number 6. I'm here today to support the amendment for 309 and extend business hours because, as you mentioned earlier, I'm one of those businesses that will be affected by it. We've had a compliance consulting, anti-money laundering consulting business for 5 years that we ran from home, me and my partner, and now we're venturing into the office location in Cedar Riverside, and we're trying to grow with aggressive plans to grow. And even though this resolution will not directly affect me, it will bring more customers to the area since those restaurants and minority-owned businesses, which I really care about, and our business is also linked to, will be open at that time. So I'm in support of this resolution in that case. Another thing, I also applaud the Councilman Johnson for bringing this resolution, because this is one of the things that we need in communities of small businesses, especially new Americans, because one of the things that we really have to be mindful is the ability to allow businesses to be flexible when it comes to dealing with resolutions and if I may use the word red tape from the government. Removing that restriction allows the businesses to concentrate on making their businesses grow and also increasing their bottom line. And I think this will be this resolution that will bring one step further. Even though it's a temporary, I think it'll be a first good step, and I've also submitted a much more version than speaking. I'm not a great speaker, but I've put my in writing, so I really appreciate this, and thank you so much.
Thank you for your testimony. Is there anyone else here to speak to this issue? Anyone? Anyone? Seeing none, I'll close the public hearing. This is only going to be allowed one night at a time, up to 34 times a year, correct?
I believe it's up to 35 times a year, and it could be 35 consecutive days, and that was to accommodate some religious holidays.
But it's not like we have 365 days a year and now every business can be open 24 hours every day, as kind of was suggested by this testimony, how it'd be great for business because now they could get around the zoning laws and be open all night. That's not correct, right? It's for special events up to 35 days a year, asking one night at a time, even if they're consecutive.
Madam Chair, I believe that is correct. If they wanted to have this open all the time, they could apply for a full year extended hours license and have a public hearing in front of this board.
Right, okay. Councilmember Fry.
Mr. Wilson, under the current framework, restaurants and bars are already allowed to serve food past the 2 a.m. barrier, is that correct?
Madam Chair, Councilmember Fry, in certain zoning districts, and I'm not sure if it's only downtown, but on-sale liquor establishments can stay open all night for late night food by applying for a license for that.
Thank you.
Councilmember Warsame.
Thank you, Madam Chair. First of all, I'd like to thank Grant Wilson for the work he's done on this issue, and also Councilmember Johnson for bringing this up. As one of the council members representing the downtown area, along with my colleagues, Chairman Goodman and Councilmember Fry, I have often heard of missed opportunities around hours of operations. And I would like to make sure that whatever extensions we're given is extended to the downtown area. That's one. The other thing is, over the last 10 days, we've received numerous calls from small East African businesses that are located in Ward 6. I mean, as you are aware, majority of the East African population, as well as the businesses, are located in the ward that I represent. And we received telephone calls in support of this ordinance from the Minnesota Halal Market Association, the Somali American Chamber of Commerce, Afri Grocery, and African Safari and Meat Market, all requesting for this opportunity. So I would like, again, this is something that we've highlighted to the community once we heard that it was coming, and we've received a lot of support. This ordinance provides the flexibility. I've heard the business community request. It allows for the businesses to operate later than the regularly authorized hours for up to 35 days, just like Grant Wilson just mentioned. Yet staff has found a balance to address the impacts on the neighboring community by requesting a business plan. And I also commend that as well, because some of these businesses are located in areas where there's a large families and large population. So having that balance of allowing flexibility, but also allowing a business plan along with the fee is also welcome. So I commend the staff for the work they have put into making this a beneficial proposition for our city, and I support it. And I also I'll make a move to approve this as well.
Okay, so we have a motion in front of us. Councilmember Johnson, you don't have a thing. Did you want to say something?
Certainly.
You don't have a.
Thank you.
You don't have one of these.
Absolutely. Thank you, Madam Chair. And I just wanted to thank staff as well, reiterate that, for working to really strike a good balance here between residents and the community and the need to help businesses be as successful as possible. I think they've done a really great job putting together a final package here that we see before us where it's not overly burdensome to businesses. And I think that there's so many occasions, from special events. We have the NCAA that we're very excited to see coming to town, thinking about that event coming to town, thinking about Ramadan, Chinese New Year, even the upcoming holiday shopping season, and the ability for businesses to stay open later and be able to serve more customers, and hopefully end up in a situation like Pizza Luce where they're looking to actually expand their business because they are being so successful within the community. So thank you to the committee and to staff and all those who support this, and it's exciting to see.
Further comments or questions on Councilmember Warsame's motion? All in favor signify by saying aye.
Aye.
Any opposed? That item is approved. On to item number 9, Mr. Wilson.
Madam Chair, we also have a second ordinance amendment to review today, and a public hearing is required for this review. And it deals with administrative hearings for when a business license is being reviewed for a possible adverse action, such as suspension or revocation. Currently, we have 2 options to hold hearings with the license holder. The first is a hearing with the Minnesota Administrative Law Center in St. Paul, where a hearing is held by an administrative law judge. The law judge conducts the hearing, collects evidence, hears testimony, prepares findings of fact, conclusions, and recommendations, and then those recommendations are presented to the City Council for consideration. We have chosen to take very few cases to that administrative law judge process, as it takes several months to schedule and the cost of the hearing is considerable. The other option that we have is to bring an adverse license action hearing to this committee, where you would collect evidence, hear testimony, and a vote is made to take action or not towards a business license. The city attorney's office then prepares the findings of fact, conclusions, and recommendations, etc. Such hearings are rarely held at the city council level, as the hearings can often be prohibitively time-consuming. Currently, cases taken directly to the city council through this committee are those that have few disputed facts, such as requests to deny the license by the Minnesota Department of Revenue for tax delinquencies, or license denials for unpaid fees or incomplete applications. The ordinance before you today would, if adopted, would add a third hearing process option by allowing administrative hearing officers to hear cases. The city of Minneapolis currently uses this type of hearing officer process for our rental dwelling licenses, for all our assessment appeals, administrative citation appeals, etc. The ordinance just never allowed business licensing cases to be presented in that way before. That hearing officer will conduct the hearing, collect evidence, hear testimony, and prepare findings in fact for the city council to consider. Staff did share this proposal with our business advisory committee, and the response was supportive. We sent notice of today's hearing and copies of the proposed amendment to all business and neighborhood associations of record, and we have placed this on our website. Staff recommends that you adopt the ordinance as written. As far as the public hearing notice, we received no responses for or against this amendment from our notification process. And I stand for any questions.
Are there any questions for Mr. Wilson? Okay, I want to note this has been vetted pretty thoroughly with Vice Chair Fry and I, and we think this is a very good solution to get faster resolution to business license issues while not putting it in front of the City Council to adjudicate. So we'll open the public hearing on item number 9, which is a change in the administrative hearing process for business licenses. Is there anyone here to speak to this issue? Anyone? Anyone? Seeing none, we'll close the public hearing. I'll move approval. All in favor signify by saying aye.
Aye.
Any opposed? That item is approved. On to item number 10. Mr. Curtis, welcome.
Madam Chair, members of the committee, thank you. What you have before you are a couple of actions. One is for preliminary and final approval of up to $5 million of 501c3 bank qualified, bank direct, tax exempt MCDA revenue bonds for Catholic elder care and affiliates. There's also a request for host approval for the issuance of additional bank qualified, bank direct bonds by the city of Lauderdale and the city of Mounds View for this project of Catholic elder care. The project itself involves the refunding of 2 series of 2002 bonds, the refinancing of an outstanding note with Wells Fargo, and the actual construction at the facility, which is about $8.4 million. The financing is $5 million proposed from the MCDA. The city of Lauderdale will do $10 million. The city of Mounds View will do $4 million. The actual construction at 900 2nd Street Northeast will add 24 additional skilled nursing home beds. These are not new beds. They were purchased from outstate, so it's not impacting that aspect. These are going to specialize in post-acute care services following hospital stays. There will also be some additional improvements at the space. There will be 15,500 square feet of new, or 25,500 square feet of new construction. All of these bonds are privately placed with a group of banks that are led by Northeast Bank. And we have representatives here for any questions that you might have.
Are there any questions for Mr. Curtis? Seeing none, thank you for your report. We'll open the public hearing on item number 10, which is a two-part public hearing, Joint Community Development Agency, Operating Committee, and CD Committee. Two-part report, adopting preliminary and final approval for $5 million in bonds, as well as offering up local consent to have other cities host a bond issuance. Is there anyone here to speak to this issue? Anyone? Anyone? Seeing none, we'll close the public hearing. Councilmember Quincy.
Thank you, Madam Chair. I'd like to move approval of this item.
Approval of item number 10 has been moved. Further comments or questions? Seeing none, all in favor signify by saying aye.
Aye.
Any opposed? That item is approved. On to your next item, Mr. Curtis.
Thank you, Madam Chair. What you have before you is a fairly straightforward request to approve the modification of a Series 2010 501c3 bank qualified bank direct revenue bonds. This is simply going to change some of the terms, which really relates to the interest rate on the outstanding bonds. The length of the bonds will not change. There is no project to be changed. The original bonds were used in Minneapolis for the Chrysalis Center at 4432 Chicago and the Tubman Center East in Maplewood. These are all held by Bremer Bank, and they will continue to be, and the interest rate is simply being reduced, but approval of that is required from MCDA.
Are there any questions for Mr. Curtis on item number 11? Seeing none, thank you for your report. We'll open the public hearing on item number 11, which is preliminary and final approval of modifications to MCDA Series 2005 501c3 bank qualified bank direct tax exempt revenue bonds. Is there anyone here to speak to this issue? Anyone? Seeing none, we'll close the public hearing. Councilmember Frye.
Thank you, Madam Chair. I move approval of this item.
Approval of item number 11 has been moved. Further comments and questions? Seeing none, all in favor signify by saying aye. Aye. Any opposed? That item is approved. We'll move on to item number 12. Mr. Werchus, welcome.
Good afternoon, Madam Chair, committee members. John Werchus, Director of Traffic and Parking Services. Item 12 in front of you relates to the Convention Center Hotel parking ramp lease. The Convention Center Hotel is also known as the Hilton Hotel, so folks can understand that relationship. Currently, the city and the MCDA have a contract in place to lease the ramp from the MCDA to the city. And the city's been operating in the Public Works Department the ramp for the past number of years. On April 1st of this year, that lease expired. Both city staff on both CPED and Public Works missed that expiration. And so we're in front of you here today to seek, as allowed in the contract, a 10-year extension to that ramp lease agreement between the city and the MCDA. So with that, Madam Chair, I will pause for any questions.
So my question is, why doesn't the city own this ramp instead of the MCDA?
Madam Chair, the way that the property was initially put together, all of the hotel property, as I best understand it, is owned by the MCDA. And maybe Ms. Newman would like to elaborate or could elaborate more on that, but as I understand, the hotel as well as the parking ramp are owned by the MCDA.
Okay, that might be true. That's great. I want to know how we get from here to there to have it owned by the city. I mean, the MCDA is a shell corporation, essentially, that's set up to be able to issue some bonds. We serve as the MCDA. Mr. Werchus has to come to us instead of just going to TMPW. It doesn't seem very streamlined. I've kind of directed him already to figure this out, and he said we can't without staff direction. So is it impossible to transmit these? This is the only asset remaining, correct? Because the hotel we don't own anymore.
And I think Madam Chair, members of the committee, I believe the MCDA owns 2, 3, 4 major projects still from, that were originally developed by the MCDA. And 10 years ago when we did the reorganization of the development function, we transferred the vast majority of the MCDA's projects and programs and assets and loans and et cetera to the city of Minneapolis, but for a variety of reasons that were identified in 2004, which I don't recall today, a few of the assets were retained by MCDA, I think due mostly to the complexity of the organizational, of the project structuring and or some impediment in the deal that made transfer difficult, if not impossible. And I think at this point, what we could do is go back and look at this particular project and figure out if there was a clear path to doing the transfer, what it would entail, and we could report back in a couple months or something.
Okay, thank you for that. I mean, 10 years ago, no one thought the merger would last either. 10 years ago, MCDA staff thought they would outlast many of us. They didn't. So I mean, there's lots of reasons why it might not have been transferred over, but the truth of the matter is Mr. Wirtjes operates parking ramps. His staff operates parking ramps. That's what they do. To have one parking ramp completely separate, treated separately by a different agency that is exactly us, and to have to even have an item like this on our agenda makes no sense to me. So I just happen to see it in agenda setting. I understand we can't get there as quickly as I would like, and obviously we want you to have an agreement to operate the ramp, and you shouldn't even have to be wasting your valuable time here today discussing this. So we will open the public hearing, and I'll make a staff direction. If it's impossible to do, I can accept it's impossible to do, but I would guess it's just something that was laying around from 2004 by someone who said, oh yeah, this merger thing, it won't work. Let's not take everything apart. Mr. Lutz is laughing because he knows that's probably true. And let's not undo everything right now and see how it goes. I think most people agree it went well, and we can probably move in this direction. So we'll open the public hearing first on authorizing the execution of an amendment to the Convention Center Hotel parking ramp lease contract, renewing the lease for an additional 10 years. Is there anyone here to speak to this issue? Anyone? Anyone? Seeing none, I'll close the public hearing. I'll move approval of the staff recommendation and provide a staff direction to look at what it would take to move this ramp into the governance and financial structure of the city of Minneapolis and out of the MCDA as an entity. Are there further comments or questions on that motion? Seeing none, all in favor signify by saying aye. Aye. Any opposed? That item is approved. I will note we have one item as a quasi-judicial hearing, and then we have one item, item number 29, the Upper Harbor Terminal issue, and I will turn over the chair to Councilmember Fry to lead our quasi-judicial public hearing.
Thank you, Madam Chair. As you said, we have one item today, which is a rental dwelling license, 3519 15th Avenue South. The owner is 226 Maple, LLC, and Alfonso Morales. And the recommendation is to revoke, and Ms. Dowling is here to present.
Good afternoon, Madam Chair, committee members. The property involved in this action is 3519 15th Avenue South. This is a residential single-family dwelling. Alfonso Morales is the owner of record and obtained a license to operate this property as a rental business in January 2013. On September 23, 2013, an inspection was conducted, which resulted in a written notice of unlawful occupancy, as well as a written order being issued to Mr. Morales, advising him to cease the use of renting the second floor west and north bedrooms, as the ceiling heights measured at 6 feet 6 inches and the requirement for the measurement should be 7 feet. Mr. Morales was given until October 16, 2013 to come into compliance. On October 1st, 2013, a notice of director's determination of noncompliance was sent to Mr. Morales, giving him until October 16, 2013 to come into compliance by discontinuing the use of the 2 second floor bedrooms. Upon reinspection, November 26, 2013, the order had not been completed. An administrative citation was issued for $250. Upon reinspection, April 17, 2014, the order again had not been completed, and a second administrative citation was issued for $500. The illegal occupancy of the 2 second floor bedrooms are in violation of licensing standard number 3 of 244.1910. On June 23, 2014, a notice of revocation was sent to Mr. Morales via U.S. and certified mail. The notice was also posted on the dwelling, giving him 15 days to appeal. The owner did appeal, and a hearing was scheduled for September 11, 2014, in front of Hearing Officer Fabian Hoffner. The respondent, Mr. Morales, failed to appear. Evidence was presented, and Mr. Hoffner made his recommendation to revoke the license. At this time, the city is requesting that you affirm the hearing officer's decision, and I would be happy to answer any questions you may have.
Thank you, Ms. Dowling. Do we have any questions for staff? Seeing none, we will open this up to the owner and/or the owner's representatives, but before doing so, I'll just read the introductory statement. This is a quasi-judicial license hearing for which this committee is limited by law to hearing argument from the property owner or the owner's representatives, but is prohibited from considering any further evidence or taking any further testimony. This means that you are required to limit your comments to arguments specifically addressing the evidence or testimony introduced before the hearing officer, which is part of the record that is already before us. So just to reiterate, we may not consider any new or additional evidence based solely on this existing record and the arguments and the parties made today. The City Council may affirm, modify, or reverse the recommendation that is before us. So we are severely limited, especially since during the appeal, the owner and or representative did not show up to begin with. That being said, is the owner or his or her representative here today to speak? Is the owner or their representative here to speak? Seeing that they are not here, I will move approval of the staff recommendation, and given that we are very, very limited in what we can consider anyway, all those in approval say aye. Aye. All those opposed say nay. Chair Goodman.
Thank you, Councilmember Fry. We'll move on to our remaining discussion item, which is item number 29. Ms. Calvert, welcome.
Thank you, Madam Chair and members of the committee. Ann Calvert from Community Development and Community Planning and Economic Development. And I'm here today recommending that you authorize the execution of an interim management agreement for the Upper Harbor Terminal with River Services, Inc. And the UHT, as many of you know, is a 48-acre parcel that's owned by the city along the riverfront in North Minneapolis from just north of Lowry to north of Dowling. And the site's been occupied as a barge shipping, intermodal shipping transfer terminal since the late 1960s. And then we've been hiring River Services, Inc., also known as RSI, to manage it on behalf of the city since 1991. It includes a pretty extensive complex of some buildings on the site for storage and then some outdoor storage areas. And as you also probably know, the goal for that site is to redevelop it for a combination of parks and business park in the near future. And we're making good progress to that end, but we're not going to be ready to start that right away next year. And in the meantime, our existing agreement with RSI is ending at the end of this year. And that's appropriate because it was built around the whole barge shipping plan. And now that the lock is closing, that needs to change. But that does leave us in a bit of a property management quandary, because unless we do something now, that property will revert back to the city to manage, and is going to be a bit of a challenge, I think. So what we're recommending is to do an interim agreement with River Services that will continue to use the site for outdoor storage on the outdoor areas and indoor storage in the domes in the warehouse, but no longer would involve barge shipping. And the term of the agreement would be 3 years, but we would have the ability to either terminate the entire agreement or take parcels out of it if, with a 1-year notice, if we're ready to start redevelopment on some or all of the site. We did go to the Permanent Review Committee, and they concurred that it was acceptable that we go ahead and initiate the discussions and work with River Services without going through a formal RFP process, given the fact they have over 20 years worth of knowledge of the site, the equipment, the buildings, which are old and have some challenges to them, and they're very aware of what the customers are who might be interested in that. So we are proposing then that we would enter into an agreement where Exhibit A has the proposed term of the agreement and also outlines the anticipated 2015 expense budget of $870,000. And under this agreement, the city will receive all the revenues, and we will reimburse RSI for all the operating expenses, and then there will be a management fee, and portions of the management fee are designed so that there's an incentive to them to get the revenue up and keep the expenses as modest as possible. And since this is a somewhat different way to operate the site than they've been doing it for the last several years, it was a little bit of a challenge to estimate the revenue expenses, but we worked with them to try to do that, and think that even though we may not get quite enough revenues to cover all of the expenses, that we're still going to be in better shape than we would be if we were operating it. So Exhibit B attempts to kind of compare and contrast those two situations, so that if city staff were operating it, we wouldn't have people on site to provide services and operation, and we think we would be much more limited in how much revenue we could generate. And we're also concerned that without some level of activity up there with trucks going in and out and et cetera, we might end up needing to put in a lot more fencing or security provisions to keep the site secure. So our recommendation today is that you would first waive the RFP process and then authorize staff to enter into this agreement. It would be a 3-year agreement, as I said, starting January 1st of next year, with a maximum 2015 contract amount of $870,000, but this would be contingent upon in December, when you approve the overall budget, that there would be funding, an appropriation to support this contract when it is approved. And I'm happy to answer any questions, and I'm also joined by Mike Wyant of River Services if there are technical sorts of questions.
Okay, so are there any questions for Ms. Calvert? Ms. Christensen, the finance is on board with where we're going with this now, correct? Okay, so it's all good. Our friends at River Services are unhappy probably about the general situation, but happy to provide the service on an interim basis for 3 years. Is that correct? Okay. I just think we have no choice. It's pretty simple. Ann Calvert's not going to be working out at the Upper Harbor Terminal doing all of the other work she does. I don't think it's right to hire an intern to have them operate the Upper Harbor Terminal, and I can't only imagine. I mean, they're going to send my dog up there to work the perimeter of the fence line that we're going to have to put in for $300,000 if we operate it. It makes absolutely no sense. This, although it is a more expensive option, is an opportunity to generate some revenue to offset the costs. It's an interim agreement. I'll note most private developers are asking for interim agreements in the 5-year period. This is a 3-year period, which says something about the city's interest in moving forward on making change at this location sooner rather than later. And I'm sorry that it was delayed, just to straighten out how finance could figure us out how to get to this answer, but the policy answer that Ms. Calvert put forward a month ago is still essentially the same, and perhaps finance had some help in figuring out the best financial way to get us from here to there. So are there other comments or questions about this solution? Thank Ms. Calvert for her hard work, and happily note you won't be working at the Upper Harbor Terminal.
Appreciate that.
Seeing no further comments or questions on the motion to approve Ms. Calvert's recommendation, all in favor signify by saying aye.
Aye.
Any opposed? That item is approved. Seeing no further business before us, we are adjourned.